Incorporation of a company is the first stage in bringing a company into existence. It involves a lot of documents, but of them, memorandum and articles are quite significant. The name of a company is selected with care to represent the main objects of the company. Multiple names will be submitted in the order of preference, and once submitted with the requisite fee, ROC on verification will give his approval for the name to be used by the company. Memorandum and articles, the key two documents, better got drafted by solicitors. Taking suggestions from ROC and getting the document vetted is more prudent. Incorporating their suggestions, the memorandum and articles could be printed and duly stamped before submission to ROC along with the registration application. Formal application for incorporation will be filed within 60 days of name approval. Form 1 with the necessary details and also declaration, Form 18 as to location of registered office, and Form 32 as regards Director, MD, Manager and Secretary on their appointment particulars and their consent as applicable. Once the memorandum and articles are registered, they have the effect of binding the company and members as if it is signed between company and each member, and all monies payable by a member under memorandum and articles shall be a debt due from him to company. And as per section 7 subsection 4, all documents and information filed with the registrar in the course of incorporation shall be records which will be maintained and preserved by the company on a permanent basis till its dissolution. At the end of the process, ROC issues certificate of incorporation in INC 11 along with the corporate identification number. Upon issue of certificate of incorporation, the company takes birth and it becomes a legal entity from the date mentioned in the certificate of incorporation. The incorporation certificate as given in INC 11 is a conclusive evidence that all the requirements of the Act have been complied with. The date as mentioned in the certificate is conclusive and cannot be amended even if it is wrong. The only solution available in the event there is an error in the certificate of incorporation is to get the company extinguished by going through the winding up and then reforming the company under a fresh certificate of incorporation. A company cannot sue nor can it be bound by a contract which is entered into before incorporation called pre-incorporation contracts, but Specific Relief Act provides for ratification where it is made for purposes of the company and is warranted by the terms of incorporation. Personal liability of agent is attracted in respect of the pre-incorporation contracts as the company is yet to come into existence. Memorandum of Association of a limited liability company. Like a nation derives all its powers from the constitution, a limited liability company derives its strength from the Memorandum of Association. Therefore, the Memorandum of Association of a limited liability company is also referred to as its charter or constitution. Section 4 of the Act stipulates compliance with the Table A to E as given in Schedule 1 while drawing the Memorandum of Association. Table A is used by companies limited by shares, while Table B is used by companies limited by guarantee not having a share capital, and Table C finds use in company limited by guarantee having a share capital. An unlimited company not having a share capital uses Table D, and having a share capital makes use of Table E. Memorandum, being a core document, is always printed and is manually signed by signatories to the memorandum. While the companies are required to comply with the contents of the Table A to E, it is the discretion of the company to have better provisions and more comprehensive provisions without contravening the contents of the tables as specified. Memorandum of a company limited by shares based on Table A starts with the first clause, Name clause. Name clause briefly indicates the name of the company coming into existence. The name is a symbol of a company's existence. It invariably refers to the main objects of the company, just like VRL Logistics talks of logistics. It should end with limited for a public limited company, private limited otherwise. It should not resemble to the name of any other existing registered company. Name being quite crucial for a company, proper care has to be taken, and the name should not suggest any connection with an unlawful activity. It should not mislead in terms of the size and area of operations of the company. And compliance with the provisions of Emblems and Names Prevention of Improper Use Act 1950 is mandatory. Name for a corporate is quite consequential. It has to be painted or affixed on outside of every office conspicuously. It is printed on all business letters, invoices, notices. Changing name has got standard procedure to follow involving special resolution, approval of central government, and filing with the registrar of companies. The second clause as per table A is situation clause or domicile clause. The situation clause or domicile clause talks of the location of the registered office of the company. It's required for receiving all official communications. The verification of the registered office is mandatory within 30 days of incorporation of a company, and the address has to appear on all business letters and notices along with the name of the company. It is required that the name and address of registered office is affixed or painted outside every place of business. Whenever the registered office is shifted within a state or between states, there is a need to obtain fresh certificate of incorporation after passing necessary resolution and getting governmental approval, followed by filing with the ROC. Objects clause is the third but the most prominent clause of the memorandum. The objects clause focuses on the main objects to be pursued by the company and also indicates the matters which are necessary for furtherance of the objects. The company is supposed to follow the law of the land and stay compliant with the Companies Act, and it can do any act which is necessary for or incidental to the attainment of the objects specified in the memorandum. What should be the objects is the pure discretion of the subscribers to the Memorandum of Association. Memorandum in general and objects clause in particular draws a line within which company has to operate. Any action outside this perimeter is called ultravires the company, which is fully void and not binding. This is the reason objects clause of a company is considered almost sacrosanct, and changing it involves complex procedure of special resolution, postal ballot, and giving an exit option for dissenting shareholders. Clause 4 is on liability of shareholders. In a company limited by shares, the liability is limited to the amount unpaid on the shares held by the members. However, in a company limited by guarantee, it is restricted to the amount which each member undertakes to contribute on winding up towards assets, liabilities and debts, expenses of winding up, and also towards adjustment of claims between contributories. Capital clause talks of the composition of the capital structure of the company. Capital clause elaborates on the types of securities and their respective face values and their share in the aggregate capital mix of the company. In the memorandum, every subscriber indicates his intention to take up shares mentioned opposite his name, and when it comes to paid up share capital, a public company must have a minimum of rupees 5 lakhs as paid up capital, and the amount is rupees 1 lakh when it comes to a private company. The sixth and the last clause of a memorandum is association clause. Association clause is declaratory in nature. The subscribers to the memorandum declare their intention to form an association, and they agree to subscribe to the number of shares mentioned against their name, and at the end of this declaration they affix their signature against their respective names and they become subscribers to the Memorandum of Association. A Memorandum of Association need to be signed by at least 7 subscribers in respect of a public limited company, and the number is 2 when it comes to a private limited company. Considering the prominence of memorandum as a primary document, its alteration is subject to a lot of restrictions. Even where alteration is allowed, it cannot require a member to purchase more shares, or it can't increase its liability in any other way. The alteration must not constitute a fraud on the minority, and any alteration in breach of a contract is also not permitted except when allowed by court on merit. Articles of Association of a limited liability company. Memorandum of Association, through its clauses domicile, objects, liability and capital, decides the external boundaries for the business operations of a company. It clarifies the area beyond which the company's actions cannot go. Memorandum answers the question who, what and where about the business of the company. Inside this area, shareholders decide on the regulations for business operations. Such regulations are collected and mentioned in the Articles of Association. Effectively, Articles of Association are a collection of the rules of the game which defines the way company and its business is carried on. The rules of the game are also known as bylaws or stipulations. They are very comprehensive in terms of binding the relationships. They bind the relationship between company and its members, and even within the community of members, it binds the relations between members inter se. Section 4 deals with both memorandum and articles. It highlights articles are to be printed mandatorily with numbered paragraphs. The model forms of Articles of Association are contained in tables F to J of Schedule 1. Table F pertains to companies limited by shares. G and H are connected to companies limited by guarantee, and I and J are used by unlimited companies. Companies articles will be quite comprehensive, covering each and every aspect of the rule of the game, but to the extent there is a gap, model form of articles in table F is by default attracted in respect of a company limited by shares, and similarly from the respective models for companies limited by guarantee and an unlimited company. While the companies have the flexibility to draft their articles, they have to ensure that the articles are in compliance with the provisions of Companies Act and any other applicable law. The articles cannot limit or restrict what is provided in the Act, nor can they permit what is prohibited under the current law. Articles as rules of the game will be quite comprehensive. For example, in respect of share capital, they will cover every minute aspect pertaining to transfer, transmission, lien, forfeiture, convening and holding of a meeting, voting rights of members, variation of rights of shareholders, dividend policy, management of reserves, capitalization, buyback, and every possible transaction which is likely to come up in the course of business. Companies always go very comprehensive and minute while forming the rules of the game. They will cover on an overall basis topics like share capital, directors, their meetings and their powers, CEO, manager, secretary and CFO, their rights and obligations, common seal and procedures pertaining thereto, accounts and audit, and winding up. The idea is to cover every aspect of a transaction that is likely to come up in the course of business operations of a company. Every subscriber to the Memorandum of Association will be signing the Articles of Association. Each signature will be attested by a witness, and full details of every subscriber, including his association with any other companies as a director or promoter, will be forming a part of documentation in respect of the articles. Section 14 authorizes alteration of articles by special resolution. It will be as effective after the alteration as before. However, it can be only prospective in its impact. It cannot have a retrospective effect. An alteration has to fulfill two conditions. One, it has to comply with the provisions of law. Second, it cannot contravene contents of the Memorandum of Association. The doctrine of constructive notice stems from the nature of memorandum and articles as public documents open to all, being documents filed with the ROC. The doctrine expects every person dealing with the company to have read and understood the documents according to their proper meaning. This doctrine protects the company against any claims from outsiders based on their ignorance on the contents of memorandum or articles or both. The doctrine of indoor management gives relief to an outsider for any internal lapses on the part of the company. It states a person contracting will not be prejudiced by any irregularities in the internal working of the company. The rule came into prominence with Royal British Bank versus Turkand 1856. The relationship between memorandum and articles is quite special. Articles are subordinate to the memorandum, and if the two are inconsistent in terms of any provision, the articles must give way and memorandum prevails. So long as an activity is done within the boundaries specified by the Memorandum of Association, whatever done in contravention of articles is just irregular. It can always be confirmed by the shareholders. Any act beyond the spectrum of memorandum is not ratifiable. If something is done beyond the Memorandum of Association, it is absolutely void and it is altogether incapable of being ratified by shareholders. Progress review of Company incorporation. Memorandum of Association defines the scope of activities and its powers in respect of a company, and there are 5 model forms of memorandum. Table A to Table E prescribed in the Act. Table A is the model that could be adopted for company limited by shares. In respect of company limited by guarantee, Table B and C are the models. B is in respect of companies not having a share capital. C is in respect of companies having a share capital. Similarly, Table D and E are in respect of an unlimited company. D is for company not having a share capital and E for company having a share capital. The name of a company has to comply with the provisions of Emblems and Names Act. A public limited company should have rupees 5 lakhs as its minimum paid up capital. The amount is rupees 1 lakh in respect of a private company. A company which has raised money through prospectus and has not fully used the amount is still lying unutilized to some extent. In such a case, the company is prohibited from changing its objects, but it can do the change if it passes a special resolution through postal ballot. Articles are stipulations relating to company and its members' relation and between members inter se. They are like bylaws of an association for day-to-day management of the company. Table F to J are models of forms for articles of association. Table F is for company limited by shares. In case of company limited by guarantee, it is G and H. H for not having a share capital, G for having a share capital. In case of unlimited company, the model table is J and I. J for not having a share capital and I for having a share capital. Alteration of articles requires a special resolution. Even when you alter an article, it has to meet 3 requirements. It has to comply with Companies Act, it has to comply with any other law in force, and it has to comply with the clauses of the Memorandum of Association. Certificate of incorporation is issued by ROC in INC 7. Upon issue of certificate of incorporation, which is like a birth certificate, a company is born from the date of certificate. The date appearing in the certificate is conclusive, and even if it is wrong, it cannot be questioned, as it is held when one certificate is given, nothing is to be required as to the regularity of the prior proceedings. The only method in respect of a certificate issued wrongly or containing objectionable things is by following the route of regular winding up of the company to put an end to it. The registrar, on registering the company, shall allot a corporate identity number, which is known as CIN. Registered office shall be open within 15 days from the date of incorporation. The company shall furnish to the registrar verification of its registered office within 30 days by filing INC 22. Ultravires is beyond legal authorization. Actions ultravires the powers of directors, but within the powers of the company can be ratified by shareholders. Constructive notice of Memorandum of Association and Article of Association is always presumed because Articles and memorandum are public documents. A person dealing with the company is taken to have read and to have understood the documents according to their proper meaning. There is one more doctrine, doctrine of indoor management. It says if the contract is as per the public document, that is memorandum and articles, the person contracting, that is an outsider, he will not be prejudiced by irregularities in the indoor working of the company. Pre-incorporation contracts are contracts made before incorporation. Nobody can sue the company based on pre-incorporation contract, but there is an exception where the contract is warranted by the terms of incorporation. Company is bound by that contract. Where a company changes its registered office, a notice of every change shall be given to the registrar within 15 days of the change. Where shifting of registered office within the same state from the jurisdiction of one registrar to the other is involved, filing is required in INC 23, filing to be done with the regional director. The regional director shall communicate confirmation of shifting of registered office within 30 days of receipt of application. Whenever articles are altered, one has to file INC 27. The company is to file a copy of the order of the tribunal approving the alteration of articles with a printed copy of altered articles within 15 days.